today's episode of Law and Batting Order. I'm your host, Tony Oyakasas. Here are some quick hits from the past week. And yet again, we won't be seeing a potential Triple Crown winner in this year's Belmont Stakes race. On Friday, it was announced that the horse, I'll Have Another, suffered a leg injury that would prevent him from racing the Belmont Stakes this past Saturday. I'll Have Another's trainer, Doug O'Neill, said that the horse had swelling in his tendon that indicated the beginning of tendinitis, thus making the tough choice of retiring him. I'll Have Another was in contention to be the first Triple Crown winner in 34 years after winning both the Kentucky Derby and Preakness races. Here in Law and Batting Order, we wish I'll Have Another a smooth and speedy recovery. Nevertheless, the Belmont Stakes are now history, and in an exciting bout, Union Rags won the race by a sliver ahead of another heavily favored horse, Painter. The NBA Finals matchup is starting to take form. Over in the Western Conference, after trailing by over 15 points at halftime, the Spurs were thunderstruck as the Oklahoma City Thunder beat San Antonio in Game 6 of the Western Conference Finals. This will be the Thunder's first appearance in the NBA Finals since they went to the finals as the Supersonics in 1996. This is also their first finals appearance since coming to Oklahoma City. Meanwhile, in the Eastern Conference Finals, the Heat and the Celtics fought tooth and nail, but the Heat managed to win Game 7 and advance to the NBA Finals for the second consecutive season. This will be a very interesting matchup as it will be Chris Bosh, Dwayne Wade, and LeBron James versus Oklahoma City Thunder's young core of Kevin Durant, Russell Westbrook, and James Harden. As if this offseason could not get more interesting in the NFL, two headlines in the NFL perhaps reached the tip of the iceberg. Earlier this week, it was announced that negotiations failed between the NFL and the NFL Referees Association, thus locking out the NFLRA from potentially striking a deal with the NFL. The NFL has begun taking efforts in hiring their own referees to potentially call games during the regular season. But the biggest headline this week was that multiple former players filed a major complaint against the NFL regarding concussion-related symptoms these players faced post-retirement. This suit is the biggest concussion-related lawsuit thus far, and we'll be keeping close tabs on it as time progresses. Today's Order in the Court will be discussing the recent defamation lawsuit that Saints linebacker Jonathan Vilma is filing against NFL Commissioner Roger Goodell. Jonathan Vilma's lawsuit is related to the huge storyline regarding the New Orleans Saints bounty fund in which Goodell alleged that Vilma, among other players, embraced and played key roles in the bounty fund. While this episode will not be talking about the cause of action of defamation, I thought this lawsuit provided a great opportunity to talk about how the suit procedurally came about. After all, each lawsuit has a starting point. Thus, today's episode will discuss specifically the court's exercise of personal jurisdiction, subject matter jurisdiction, and the choice of venue in the case of the Jonathan Vilma defamation lawsuit. First, let's discuss personal jurisdiction. This case is being heard in Louisiana. In order to determine whether or not the Louisiana District Court can exercise jurisdiction over the defendant, it must be first decided if the court has personal jurisdiction over the defendant in accordance with the state's long-arm statute and the Constitution. The complaint, which you can view by clicking the link below this video, discusses a long-arm statute in Louisiana. According to Louisiana's long-arm statute, in relevant part, it says that a court may exercise personal jurisdiction over a non-resident who acts directly or by an agent as to a cause of action arising from any one of the following activities performed by the non-resident: transacting any business in the state, contracting to supply services or things in the state, and causing injury or damage by an offense or quasi-offense committed through an act or omission in this state. In this example, it could be argued that Goodell could be transacting business in Louisiana, given that he is the NFL commissioner and he oversees all NFL activity, including Louisiana, where the Saints play. Conditions 2 and 3 don't necessarily apply here, so we won't be discussing those issues. In addition, we can apply the Constitution standard of personal jurisdiction, which allows the court to exercise personal jurisdiction over a defendant so long as it abides by the rules of due process or fairness. To determine if personal jurisdiction can be exercised over the defendant, it must be determined if the defendant is domiciled in the forum state, if the defendant has consented to the complaint, or was personally served in the forum state, as per the case Penoyer v. Neff. In this case, the complaint indicates that Roger Goodell, the defendant, is domiciled in or a citizen of New York. Thus, he is not domiciled in the forum state of Louisiana. We also have no indication that Mr. Goodell consented to the complaint or was personally served in the forum state. While penurious factors do not apply here, we can apply the minimum contacts test, which is set forth in the cases of International Shoe versus Washington and Worldwide Volkswagen versus Woodson. As a matter of clarification, minimum contacts are the contacts that the defendant has maintained with the forum state, such that the defendant has purposely availed himself in that forum state, and exercising jurisdiction over the defendant would not interfere with the notion of fair play and substantial justice. According to Worldwide Volkswagen, a court can determine if the plaintiff maintained contacts that were casual and attenuated but unrelated, one or a few but related, continuous and systematic and related, or continuous and substantial but unrelated. After this, the court can apply several convenience factors as per McGee and Hansen in determining whether or not personal jurisdiction should be exercised. These convenience factors include state interest in preventing the act, the burden on the plaintiff and defendant to have the case heard in the forum state, the presence of witnesses in the forum state, and an efficient resolution to the problem. In this case, the complaint asserts in paragraph 3 that Goodell transacted continuous and systematic business in Louisiana and in this judicial district, and his defamatory statements were continuously transmitted in this judicial district. This continuous and systematic activity was related to the contact with the forum state. After all, as mentioned previously, given that he is the NFL commissioner, he oversees all activities in the NFL, including what happened in Louisiana with the Saints and their bounty fund. Convenience factors could also be weighed in, and the argument can be made that it would be convenient for both Goodell and Vilma to have the case in Louisiana, given that both maintain consistent contact with the forum state. The presence of witnesses in the forum state would also be another convenience factor applicable in this case. Vilma could bring in fellow Saints teammates who may live in the state to testify as to his involvement in the bounty fund and testify as to how Goodell's actions were defamatory. In this sense, this is how personal jurisdiction has been established. But the next step is to determine if the district court in Louisiana can exercise subject matter jurisdiction over Goodell. The two fundamental types of subject matter jurisdiction are federal question jurisdiction and diversity jurisdiction. Federal question, which deals with a federal statute in dispute, does not apply here. However, diversity jurisdiction applies. The constitutional aspect of diversity jurisdiction under Article 3, Section 2 states that diversity jurisdiction can be exercised when there is no dollar amount in the suit and complete diversity is not required. However, this is too broad, so courts abide more by the statutory aspect of diversity jurisdiction as per Title 28 of the United States Code, Section 1332, stating that diversity jurisdiction only applies in a claim when the suit is more than $75,000 in damages and there is complete diversity between the parties as per Strawbridge. Complete diversity, according to the case of Mass v. Perry, states that a person is domiciled in a state when he physically moves to that state with the intent to remain there. In this defamation lawsuit, subject matter jurisdiction has been satisfied according to paragraph 2. Jonathan Vilma's attorney is asserting damages that exceed the $75,000 limit. In addition, there is complete diversity between the plaintiff and the defendant. In paragraph 5 of the complaint, it states that Jonathan Vilma is a citizen of Florida, while paragraph 6 states that Roger Goodell is a citizen of New York. Finally, let's discuss venue. This case is being heard in the Eastern District of Louisiana. According to 28 U.S.C. Section 1391, a case is heard in the place where the defendant is domiciled in the forum state, where the district is located, or where the defendant's actions substantially took place where the district is located. Here, the defendant, Roger Goodell, is not domiciled in the forum state, but the actions of defamation that Vilma is arguing occurred in the forum state of Louisiana, specifically in New Orleans, which is located in the Eastern District. This is because the Saints play in New Orleans. A discussion can be set aside for a later time as to whether or not the suit will stand, but as far as the procedural aspect of this case, this is how the court is able to hear the case and exercise personal jurisdiction and subject matter jurisdiction over Roger Goodell. That's the show. Leave all your comments down below, and be sure to visit Law and Batting Order at lawandbattingorder.com, as well as on Facebook and Twitter. Till next time, have a great week, guys.